Your elected lawmakers are under pressure to support a plan that could stop mass shootings before they happen. 17 states have so-called red flag laws that allow authorities to take guns from someone considered dangerous. President Donald Trump says he supports the idea. CBS 46's Carolyn Ryan is live at the state capitol this evening. Carolyn, state lawmakers have already considered this idea here.
Yeah, Megan, that's right. And I wouldn't necessarily say that our state lawmakers are under pressure to support it, but certainly there's more attention on the issue now than there was in February when this House bill was originally put forth here at the state capitol. Of course, that bill was to implement a red flag law here in Georgia. The bill went nowhere, but the state legislator who proposed it is hoping it gets a fresh look in the upcoming session. After two back-to-back mass shootings, President Trump is calling for stronger background checks and the passage of red flag laws, a measure freshman State Representative Matthew Wilson already proposed earlier this year.
And the whole idea behind red flag legislation is to prevent tragedies before they happen.
Red flag laws would allow family members or law enforcement to petition the courts to confiscate guns from someone they believe is a danger to themselves or others. But opponents say red flag laws are a huge concern and a very slippery slope. What constitutes, quote, threatening or dangerous behavior? And would that infringe on a person's freedom of speech? How would law enforcement go about confiscating a person's firearms? What if someone accused a person of threatening behavior for political or personal gain? Jerry Henry with GeorgiaCarry.org says, bottom line, red flag laws are unconstitutional and impractical.
I don't think most policemen want to do that. They don't want to be involved. The sheriffs don't want to be involved in confiscating firearms. But there's no crime being committed. It's just somebody said, well, I think he's going to commit a crime.
Wilson insists, though, his bill would provide due process.
It requires any action that takes place has to be in a court. And there would have to be a showing of clear and convincing evidence that there is an extreme risk posed before any order could be entered.
And he says if a defendant feels they've been wrongly targeted, he or she can always appeal. Not good enough, says Jerry Henry.
You just shouldn't have to go through appeals to prove yourself innocent when nobody proved you guilty to begin with.
Now, we went ahead and pulled Representative Wilson's bill, House Bill 435. We went through it line by line, and there's a number of provisions in here that may explain perhaps why it didn't really get much traction in last session. For example, when a judge is considering if a person should have their guns removed, they can consider things like whether that person has been arrested for, not even necessarily convicted of a crime. Also, another provision that caught our attention here was that, according to this bill, the defendant would have the burden of proof, not the person accusing that defendant. So a lot of caveats here that make it a bit more complicated. We'll see if it gets attention in 2020. Reporting live from the state capitol, Carolyn Ryan, CBS 46.